Hey guys, thanks for completing your quizzes last week. If you had any issues with that, email me and we'll see what we can do. Those should have been due on Friday. Next week, you're gonna have your first exam, so that will cover everything that we're covering this week, all the way back to the beginning of the semester, and it'll be the same way that we did the quiz. I think it is 25 or 30 questions. I don't have it in front of me right now, but it's still multiple choice. Will be uploaded on Blackboard the same way. So we'll get through 2 chapters this week, and then next week you will just have the exam, and that will be all that you'll have that week. All right, so right now we're going to dive into fundamental American liberties. So the chapter starts out talking about what's at stake in things like regulating gun ownership. Obviously, in 2012, the Sandy Hook Elementary School shooting, there was, President Obama at the time vowed to outlaw assault weapons. He formed a task force on gun violence with Vice President at the time, Biden, leading it. He proposed that Congress pass legislation banning assault weapons, requiring universal background checks on gun purchases, limiting magazine capacities. Former Congresswoman Gabby Giffords, who had been shot in a mass shooting, formed a group called Americans for Responsible Solutions. Former New York Mayor Michael Bloomberg formed Everytown for Gun Safety. There were record donations to the Brady campaign to prevent gun violence, yet nothing happened. Speaker Boehner, who's the speaker at the time, and I was actually in Capitol Hill at the time, he expressed a lot of regret. He probably cried. He cried a lot. Not say anything about him. He was a good guy. But he didn't have any action that he could promise. He couldn't. There was a Senate compromise bill on background checks, and it failed. There was just really nothing they could do. It was outside of the control of the leadership at that point. So what's at stake, Patrick Henry, at the beginning of the Revolutionary War, give me liberty or give me death. Americans put a lot of stock in their freedom. Certainly that they live in the least restrictive country in the world, but collectively we live in a government, which means we are free to do we aren't free to do what we want. We have limits on our freedoms that allows us to live peacefully with others instead of the chaos of everybody doing exactly what they wanted. John Locke said liberty doesn't equal license. The freedom to do some things does not mean the freedom to do everything. Deciding what rights we give up to join a civilized society and what rights we retain is one of the great challenges of a democratic government. Civil liberties. These are individual freedoms guaranteed to the people primarily by the Bill of Rights. They protect our right to think and to act without government interference. Then civil rights are the citizenship rights guaranteed to the people primarily in the 13th, 14th, 15th, 26th, 19th, and 26th Amendments and protected by the government. This is usually an extension of government action. Usually means that the government must treat all citizens equally, apply laws fairly, and not discriminate unjustly against certain groups of people. You distinguish between authoritarian government and non-authoritarian government. The non-authoritarian government, including democracies, give citizens the power to challenge a government if they believe it has denied them their basic rights. Democracies depend on the existence of rights. Civil liberties provide rules that keep government limited so that it cannot become too powerful. Civil rights help define who we, the people, are in a democracy and give those people the power necessary to put some controls on their government. We take a lot of freedoms for granted. We speak confidently of our freedoms of speech, of press, of religion, of our right to bear arms, of a fair trial, of privacy, but none of that is inevitable. During the Enlightenment, John Locke wrote about the first real discussions of rights at all. Nobody really claimed rights against the government. Instead, they thought that the government had all the power and only gave subjects privileges they were willing to bestow. John Locke said we had the right to life, liberty, and the pursuit of property, and those were conferred on us by nature, and the government should preserve natural rights of its citizens. This was central to our founders. Obviously, we said the pursuit of happiness instead of the pursuit of property because there were some disagreements about what that meant. Practically speaking, a government can do whatever it wants as long as it wants to remain in charge, as long as they remain in charge of the police and the military, right? But public opinion is really outraged at the invasion of individual rights. Unless a government is willing to dispense with its reputation as a democracy, it must respond in a way to pacify public opinion, which can be a powerful guardian of citizens' liberties in a democracy. A person who successfully claims that he or she has rights must be respected by a government that is a citizen of that government. A person who is under the authority of a government but cannot claim rights is merely a subject, bound by the laws but without any power to challenge them. And that's what we fought against when we formed our country. We did not want to be citizens of a monarchy. Or subjects of a monarchy. We wanted to be citizens where we can have rights of our own. This doesn't mean that a citizen can always have things their way, and nor does it mean that a non-citizen has no rights in a democracy, but citizens do have special protections and powers that allow them to stand up to government and plead their cases when they believe an injustice is being undone. The first type of rights conflict occurs between individuals. One person wants to pray with classmates, another student doesn't want to be subjected to a religious practice against his will. We have our right to know who we elect might be conflicting with the candidate's right to privacy. The second way rights conflict is when the rights of individuals are pitted against the needs of a society and the demands of a collective living. For example, the decision to wear a helmet or a seatbelt, it seems like an individual decision, but society has an interest in regulating these behaviors because jeopardizing one's safety is costly to society in terms of loss of talent, wasted public investment in a person, cost of medical care, etc. One of the most important aspects of claiming and defending rights is building and perpetuating, I need more coffee, a narrative that the right you claim exists and that you often deserve to have it. There are often competing narratives, like women have a right to their own health without government influence versus a government must protect the rights of the unborn. Guns are protected under the Constitution versus it's a privilege that the Constitution allows to be regulated. When rights conflict, you think about things like after 9/11, national security, Americans were really afraid, so the government federalized airport security and started screening passengers. They started searching luggage and allowing armed agents on planes, but kept a close eye on folks suspected of having ties to terrorism. We allowed this because we felt it was to our benefit. The Patriot Act in 2001, it made it easier for law enforcement to do things like intercept our email and conduct a roving wiretap, allowing immigrants suspected of terrorism to be held for up to 7 days and sometimes indefinitely without being charged. This may have increased the security of citizens, but it reduced our civil liberties. But when we're at threat, most Americans think it's worthwhile, and somehow a reduction in freedom doesn't seem unreasonable for a reduction in fear. Obviously, folks like the ACLU criticize the law for infringing on our privacy, violating due process, being discriminatory. Some members of Congress have tried to repeal parts of the Patriot Act, but it has been reauthorized under both Bush and Obama, so I think it's here to stay. And the delicate balance between security and freedom, on which side should we err? Obama stopped the practice of waterboarding, but Americans are more willing to tolerate the reduction of freedoms when they come at the expense of non-U.S. citizens. The balancing of public safety with an individual's right is complex. We could likely ensure more safety from threats if we gave up all of our freedoms, right? If the government could monitor all of our movements, they would know who would endanger us. But without civil liberties, we'd have no protection from the government itself. It's a tricky balance. How can we resolve conflicts about rights? This often is politics at its messiest, and there are lots involved, like courts, Congress, the president, and people themselves. One of the jobs of the courts is to arbitrate disputes among things like rights. The Supreme Court is usually the judge of what is fair, but the rulings often change as the membership of the Supreme Court changes. They're human too. Founders wanted the Supreme Court to be above the political fray, but they're still subject to a lot of political pressure. The ideology of a president who appointed them, the influence of public opinion, the media. At times in our history, the Supreme Court has championed what seems like the underdog interests that fight the mainstream of the American public opinion, like ruling in favor of someone who won't salute the flag because of religion. And then at other times, Supreme Court has favored the interests of big business over the rights of the ordinary. Like they put the stamp of approval on the World War II incarceration of Japanese Americans in internment camp, which we have since apologized for. And then Congress. Sometimes Congress chooses to stay out of disputes about rights. Sometimes they take divisive action to limit or expand our rights. For example, the Smith Act in 1940 made it illegal to advocate for the overthrow of the government. Sometimes Congress protects rights, like the Civil Rights Act of 1991, which broadened civil rights protections in the workplace. Things like that. The president can be involved by lobbying the Supreme Court to encourage outcomes they favor. In the 50s, Eisenhower was reluctant to enforce desegregation in the South because he thought it was up to the states and not the federal government. JFK chose to be more actively involved and sent Congress a civil rights bill in 1963, so it can be taken different ways. The people, Americans sometimes use the courts to sue for what they perceive to be their rights, but they often act in groups. Groups like the ACLU, NAACP, Sierra Club, etc. They engage in fundraising and PR to publicize their views, to work to influence government directly by meeting with lawmakers and testifying at a congressional hearing. Their group efforts magnify a voice and can be considerably influential. So the Bill of Rights, we talked about this a little bit, so let's dig into that a little more. Had a stormy birth, right? there was a controversy about whether a Bill of Rights was necessary. It really deepened the split between the Federalists and the Anti-Federalists during our founding. Controversy didn't end once it was added in the first 10 amendments. Over a century passed before the Supreme Court agreed that at least some of the restrictions imposed on the national government should be applied to the states also. So why are they valuable? The Federalists argued that the Constitution itself was a Bill of Rights, and that individual rights were already protected by many state constitutions, and to add to the list of powers the national government did not have was dangerous. This implied that the government had every other power. Hamilton, I mentioned this before, Hamilton spelled this out in Federalist 84. Madison agreed at first, but then came to agree with an anti-federalist, such as Thomas Jefferson, who wrote that a Bill of Rights is what the people are entitled to against every government on earth. Government is limited in principle by popular sovereignty, which is the authority of people. So it couldn't hurt to limit the practice in the specific list of rights that would give the judiciary a better check. Some rights are protected in the Constitution itself, like habeas corpus, the right of an accused person to be brought before a judge and informed of the charges and evidence against him or her. Bills of attainder, laws under which specific persons or groups are detained and sentenced without trial, and ex post facto laws that criminalize an action after it occurs. Incorporation. So the Supreme Court really had to incorporate these first the Bill of Rights, and this was the Supreme Court action in making the protections of the Bill of Rights applicable to the states. Not all rights necessarily qualified for incorporation. The Supreme Court had to consider each right on a case-by-case basis to see how fundamental it was. And currently, almost all rights have been incorporated. Incorporation was a judicial creation. It's not an absolute constitutional principle. What the Supreme Court creates, it can also take away. What about freedom of religion? Why is religious freedom a valuable thing here in our country? When religion and politics mix, the stakes are high, passions are deep, compromise is difficult. The United States has been spared a lot of violence because of our First Amendment protections, but it still isn't without controversy, because it does establish general guidelines which most people can agree with, and says that the courts are where you address your concerns. This has kept us from violence in the battlefield. Perhaps a constitutional battleground, but it has kept the United States from becoming a literal battleground by deflecting religious conflict to the courts. Founders based their religious freedoms on two arguments. First, that history has shown that linking church and state can have a negative impact on secular life. This puts all individual freedoms in jeopardy and reduces population to subjecthood. If a government is merely an arm of God, what power of the government can be justified? If Madison feared that religion could have a divisive effect if it became linked to the government. And then second, the effect politics can have on religious concerns. They worried that spiritual purity and sanctity of religion would be ruined if it was mixed with the worldly realm of politics that emphasized power and influence. So the Establishment Clause. This is the First Amendment guarantee that the government will not create and support an official state church. Separationists are supporters of a wall of separation between church and state. Accommodationists are supporters of a government non-preferential accommodation of religion. States shouldn't be separate from religion, but rather accommodate it without showing preference for one religion over another. Arguments that the First Amendment should not prevent prayer in school, and they also shouldn't post religious documents in public places. What about teaching Bible stories, creation, along with evolution? There are adherents that claim that a rigid interpretation of separation of church and state amounts to intolerance of religious rights, or according to Justice Kennedy, unjustified hostility to religion. Bush and Reagan and many establishment Republicans share this view. So the Lemon Test. The United States somewhere kind of stands between these two views. Congress opens with prayer, but the school day doesn't. The Supreme Court generally leans toward a separationist stance, but the court has become more conservative, and rulings have moved more in an accommodationist direction. The Lemon Test is a three-pronged test used by the courts to determine whether the Establishment Clause is violated. I took an entire class, I feel like I say this all the time, I took an entire class in law school on the First Amendment, and prayer in schools and things like that. It was really very fascinating class. I had a really great professor on that. But of course, we are just blazing right through this. If you guys go to law school, you'll have at least heard of it before. Lemon versus Kurtzman in 1971. A law must not foster an excessive government entanglement with religion. The Free Exercise Clause. This is the First Amendment guarantee that citizens may freely engage in the religious activities of their choice. What about when religious beliefs against killing clashes with compulsory military service during war? When religious holy days are ignored by a state legislature about on when an individual is expected to be at work. In the 1940s, there was a difference between freedom to believe and freedom to act on these beliefs. We can believe whatever we want, but freedom to act is subject to government regulation. The police power is the ability of a government to protect its citizens and to maintain social order. If a state needs to regulate behavior, it may. And then there's something called the compelling state interest test. If a fundamental state purpose, which must be shown before the law can limit some freedoms or treat some groups of people differently, was rejected in 1990 by the Supreme Court, where it held that the infringement on religion is not intentional, but rather the byproduct of of general law prohibiting socially harmful conduct applied equally to all religions, then it's not unconstitutional. So religious groups consider that a major blow to religious freedom because it places the burden of proof on the individual or the church to show that their religious practices should not be punished, rather than on the state to show that their interference is absolutely necessary. In 1993, Congress responded and passed the Religious Freedom Restoration Act, which restored the compelling state interest test. You guys, we'll get into the weeds a little bit on this. Again, this is an entire class in law school. There are some concerns over religious freedom that grew after Obamacare was passed. It required employer-based health insurance that provided birth control coverage. The Hobby Lobby case in 2012 decided that corporations that are not publicly traded did not have to provide this coverage if it violated the owner's religious beliefs. This affirms some rights for corporations and for individuals. All right, so what about the freedom of expression? This is one of the most cherished American values in the right to free speech, right? But Congress makes laws abridging our freedom of expression, right? We tend to restrict speech we don't like, admire, respect. The challenge is to protect the speech we despise. In a democracy, citizens are responsible for participating in government decisions, but to participate wisely, we need to be informed. So we need at least a free press to be able to report on our government. By being able to voice criticism of our government, we need to have a journalist watchdog check to keep government accountable. There's a danger of setting a precedent of censorship. This is when the voice of the majority prevails. So we need to support minority rights and majority rule because we never know when we may fall into the minority and therefore could be censored. John Stuart Mill said, "Free traffic of all ideas, those known to be true as well as those suspected to be false, is essential in a society that values truth. We must allow expression of all ideas to discover truths previously believed to be false." This is controversial. It requires the tolerance of ideas and beliefs other than our own, even ideas and beliefs that we maybe find repugnant. What about speech that criticizes the government? Sedition is speech that criticizes the government to promote rebellion. It's long been the target of restrictive legislation, though the founders were in a daily practice of criticizing their government when they were in the process of inciting revolution. They realized, though, that if the shoe was on the other foot, they were far less willing to encourage dissent. They felt that criticism of the government undermined authority and destroyed patriotism. So there were some early restrictions on speech. The Alien and Sedition Act of 1798 outlawed false, scandalous writing against the government. State governments in the South punished speech advocating for the end of slavery. They even censored mail to prevent distribution of abolitionist literature. And then the role of the Supreme Court here kind of comes into play. Those arrested under these new sedition laws looked to the Supreme Court to protect their freedom to criticize the government, but they were doomed to find disappointment. There's something called the bad tendency test, the rule used by the courts that allows speech to be punished if it leads to punishable actions. This is pretty easy for a prosecutor to meet, right? If it leads to punishable actions, you should be punished, right? So most convictions here were upheld. And then it moved to the clear and present danger test, the rule used by the courts that allows language to be regulated only if it presents an immediate and urgent danger. Senator Joseph McCarthy conducted investigations of American citizens to search out communists. The House Un-American Activities Committee did that. Many careers and lives were ruined by suspicion of communism. The Supreme Court began to overturn sedition. They overturned conviction of a KKK leader, ruled that the abstract teaching of violence is not the same as incitement to violence, and that political speech could be restricted only if it was aimed at producing or was likely to produce imminent lawless action, which is the rule used by the courts that restricts speech only if it's aimed at producing or is likely to produce imminent lawless action. This continues to be the standard for regulating political speech today. Many forms of expression go beyond writing. Should they be protected? When is an action a form of expression? Burning a draft card, wearing an armband to protest, torching the American flag. The Supreme Court is generally willing to allow regulation of a symbolic speech than speech alone. But what about obscenity and pornography? This probably has presented the Supreme Court with its biggest headaches. Justice Potter Stewart in 1964 famously said about pornography, "I only know it when I see it." Whether obscenity should be protected speech raises fundamental issues, including what is obscene. One means vulgarity is another means lyrics, So then you look to fighting words and offensive speech. Fighting words. This is speech intended to incite violence. The Supreme Court has ruled that this can be regulated, but rarely upholds legislation designed to limit fighting words, unless it's written very carefully and specifically. Political correctness, the idea that language shapes behavior and therefore should be regulated to control its social effects. This movement really swept our country in the 80s and 90s. So freedom of the press, prior restraint. British common law held that it's acceptable to censor writing and speech about government as long as the censorship occurs after publication. This is prior restraint, the censorship of or punishment for the expression before the ideas are printed or spoken. This is the more dangerous form of censorship since ideas never enter the public domain and their worth could not even be debated. Libel is the written defamation of character. Slander is the verbal defamation of character. New York Times versus Sullivan is a Supreme Court case that held that public officials, when suing for libel, must show that a publication acted with actual malice, not just evil intent, but with reckless disregard for whether it was false or not. You have the right to a fair trial. Media coverage often leaves it difficult to find an impartial jury, but there's also a public right to know. The Sixth Amendment, we have a right to a speedy and public trial. Journalists often think this is the public part of that means that proceedings should be open, that courts are reluctant to uphold because that could impose a prior restraint on the press. When you start looking at the internet, you can get to a conflict between authors and creators of material to claim copyright of work and the public who wants to access this work without paying full fare for their use. When I started working for Congress, we were dealing with some legislation called SOPA and PIPA, Stop Online Piracy Act and Protect the IP Act, that required internet providers to monitor their users and block access to sites that share files. A lot of sites like Google opposed it, saying that it required them to censor their users and it would stifle free speech and innovation. A lot of sites went dark in protest of this bill and ultimately killed the legislation. And the right to bear arms. Excuse me. This is a rallying point for those who want to engage in sporting activities. Involving guns, for those who believe firearms are necessary for self-defense, for those who believed an armed citizenry is necessary to check the government that might become tyrannical, and those who don't believe it's the government's business to make decisions about who can own guns. There are various kinds of gun control that's been passed at state and local levels, but the NRA keeps it to a minimum at the federal level. Why is the right to bear arms valuable? The chief source of national stability in early America was a state militia system. Armies of able-bodied men who could be counted on to assemble with their own guns and defend their country from internal and external threats. The Second Amendment was designed to guard against the tyranny of a federal government. So there are some arguments in defense of the Second Amendment. Hunting and other leisure activities are important to Americans, and restricting any of them is the start down a slippery slope. That's a major argument. We hear the slippery slope argument. The second is the possession of guns is necessary for self-defense, and that gun control means that only criminals who get guns on the black market will be armed and life will be even more dangerous. The third argument is that citizens should have the right to arm themselves to protect their families and property from a tyrannical government, just like the revolutionaries did. And fourth is just not the government's business to regulate gun use. What about some arguments against the right to bear arms? Honestly, they've struggled to create a single compelling counter-narrative of their own. They argue that none of the rights of Americans, even fundamental ones like speech and press, is absolute, so why should the right to bear arms not carry exceptions? And the irony of claiming the protection of the Constitution in upholding the Second Amendment to weapons that could be used to overthrow the government that the Constitution protects. It's a little bit of irony there. What about the rights of the criminal defendants? Half of the amendments in the Bill of Rights are devoted to protecting the rights of people who are suspected or accused of committing a crime. There is a concern for our founders who feared an arbitrary government that could accuse and imprison people without just cause. So they have the person innocent until proven guilty, which comes from our English roots. The due process of law, the guarantee that laws will be fair and reasonable and that citizens suspected of breaking the law will be treated fairly. Founders are particularly sensitive about the protection of unreasonable searches and seizures because the King of England had the right to order the homes of his subject to be searched without cause, looking for any evidence of criminal activity. There are some reasonable exceptions to that. Automobiles are a special case because they are likely to be gone by the time an officer gets a warrant to search the car. Supreme Court has gradually widened this to include luggage in the car. Wiretapping and electronic surveillance, they're more difficult. The term search was understood legally to require some sort of physical trespass, and seizure to be taking some tangible object. The Patriot Act obviously helped to make it easier to get warrants. What about a cell phone? Do you guys think that your cell phone is yours and all of the stuff on it is yours? In 2014, Supreme Court Chief Justice John Roberts said the average smartphone user has 33 apps that form a compelling montage of a user's life. Phones are mini computers that contain the same amount of information about us that our house traditionally contained. Just as houses cannot be searched without warrants, now neither can cell phones. But honestly, warrants aren't hard to come by, and so people who store information on their cell phones should be cautious. Honestly, I feel like most of us know that anything we do on the internet, on our cell phones, it's not private. We all have kind of been raised to know that now. What about random testing for drug or alcohol use, or blood or urine tests? This is an unreasonable kind of search, but the Supreme Court allows them where a violation of privacy is outweighed by a good purpose, like discovering the cause of an accident, preventing drug use in schools, preserving public safety by requiring a random drug test of an airline pilot. Then there's something called the exclusionary rule. This is the rule created by the Supreme Court that evidence seized illegally may not be used to obtain a conviction. Even if police have concrete evidence of criminal activity, if it was obtained unlawfully, it can't be used. In England, it can be used, but the defendant could sue the police. So they try to deter misbehaving police, but not allowing guilty people going free. The American exclusionary rule helps criminals avoid punishment, but it sometimes deters police. They carved out a good faith exception whereby the evidence can be admitted to a criminal trial, even if it's obtained illegally, and if the police are relying on a warrant that appears to be valid at the time, or a law that appears to be constitutional, though they may turn out to be defective, or a warrant obtained in error. In 2009, they said to trigger this exclusionary rule, police conduct must be deliberate. You also have a protection against self-incrimination. The Fifth Amendment provides for protections against for individuals, including not being a witness against yourself, expanded to a grand jury, legislative investigations, and police interrogations. Obviously, the 1966 case Miranda versus Arizona said that the police have to inform subjects of their rights to remain silent and to have a lawyer present during questioning to prevent them from incriminating themselves. These are your Miranda rights. If a lawyer can show a defendant was not read his Miranda rights, it's like the exclusionary rule. It could result in the police interrogation not being admissible in court. This resulted in criminals going free, even though the evidence was there to convict. And in 2000, Miranda was upheld as an established part of our culture. You also have a right to counsel. The Sixth Amendment says you have a right to a lawyer to present during police questioning. In 1790, the Crimes Act required courts provide counsel for poor defendants only in capital cases that are punishable by death, and defendants in other trials had the right to counsel, but the government had no obligation to provide it. Right to counsel is now seen as essential, but it's often violated because maybe an overworked public defender or a state law who can receive court-appointed counsel doesn't apply. I actually worked for a public defender one summer while I was in law school, and it was a really interesting perspective to gain on how our system works that way. The Eighth Amendment, protection against cruel and unusual punishment. What is cruel and what is unusual? The Supreme Court said not all unusual punishments are unconstitutional because maybe a new punishment like electrocution or lethal injection are unusual when they first appear, but may be more humane than an old punishment like hanging or shooting. They have not ruled that the death penalty itself is cruel or unusual, except for in cases of like mental retardation, juveniles, and crimes that didn't result in the death of the victim. But a majority of states have upheld death penalty laws. 2006, the Supreme Court held that death row inmates could challenge state lethal injections in lower courts on cruel and unusual grounds. The right to privacy. So the right to privacy, this is not spelled out in our Bill of Rights, but it goes hand in hand with the founders' insistence on limited government. They want the government to not be too powerful and not to interfere with individual citizen life, which implies a right to privacy and assumed it, but not made explicit. Is it so obviously desirable that we want to be left alone to do what we want that it scarcely needs a defense, right? But the right to privacy without limits is anarchy and the absence of government altogether. The interest in preventing some types of behavior like murder, theft, and rape, but what about more subtle behaviors that don't directly affect the public safety but have serious consequences for public good, like prostitution, drug use, gambling, riding a motorcycle without a helmet? Should this be private behavior? Should it be regulated by the state? The Supreme Court didn't really discover privacy until 1965, and whether such a right exists is still controversial. All of the Bill of Rights include limitations and contradictions, but the right to privacy is the least certain of all. What about reproductive rights? Obviously, abortion. Until the Civil War, abortion bans were uncommon. Most states allowed abortions in the early stages of pregnancy, but opinion turned after war, and by 1910, every state but Kentucky made abortions illegal. The 1960s legislation was becoming more liberal, but abortions were still mostly unobtainable. In 1973, Roe versus Wade, obviously you've heard this, the right to privacy did indeed encompass the right to an abortion. They tried to balance a woman's right to privacy and reproduction with the state's interest in protecting human life. Congress has failed to pass a constitutional amendment banning abortions, so they've passed over 30 laws restricting access in various ways, such as limiting federal funding via Medicaid. 2007, partial birth abortion was upheld, but this was no signal that Roe versus Wade will be overturned. Abortion has been a largely partisan issue. The Christian right make up a lot of the Republican Party, and Republicans usually include a commitment to abortion ban as a constitutional amendment in their presidential party platform. Usually it's a direct effort to the states. The text talks about gay rights. If there's a right to privacy, what must be included under it. Privacy grounds in cases like Bowers versus Hardwick and Lawrence versus Texas that have overturned some standards on privacy grounds. The right to die. What about, you may know, sorry, that didn't mean for that to roll together in the same sentence. My next subject. In 1990, Nancy Cruzan was a woman who'd been on life support since 1983. She'd been on life support for 7 years. Her parents were asked to withdraw life support and allow her to die, but the state claimed an interest in the sanctity of human life and blocked the request. They argued that a right to die was protected under the right to privacy, but the court said Nancy's wishes were unclear without a living will. When it's clear a person's right to terminate medical treatment was protected under the 14th Amendment due process clause. Individuals have the right to assist in ending their lives when they are terminally ill and in severe pain. Should a patient decide? Would it violate a doctor's Hippocratic oath? The Supreme Court said this is left to the states. So citizens and civil liberties. Rights come with obligations, right? We've talked a lot about a Bill of Rights, but what would a Bill of Obligations look like? Obligations are the flip side of rights. For every right guaranteed, there's a corresponding duty to use it. Provisions for elected office imply a duty to vote. Congress is authorized to collect taxes. Citizens are obligated to pay those taxes. In Europe, these obligations are explicitly extended to include providing for the welfare of those who cannot take care of themselves. Tax burdens are higher, and sometimes the obligation to vote is legally enforced. How much fulfillment is enough? We must obey laws, and most of the time, if we don't, we obey most laws, and most of the time, if we don't pay all of our taxes, we pay most of them. If we don't vote, we get involved in other ways. We are getting by as a nation for now, but perhaps we should consider the long-term consequences to a democratic republic if the emphasis on preserving civil liberties is not balanced by a corresponding commitment to fulfilling political obligation. The question that I'm going to pose for you guys today is I'm going to post this again like I always do, in the delicate balance between security and freedom, on which side should we err? Should we be a more secure nation, or should we be a freer nation? What do you think? Again, these are not intended to be essay questions. Just give me a brief little summary of what you think, and just let me kind of know that you've watched this. I'll post one more lecture this week and then the exam next week. Let me know if you have any questions, and I'll talk to you guys soon. Thanks.